Hello again, learned students of human sexuality. I'm just giving you this presentation on prostitution in the law, just to clarify a few things about in recent years, the challenge to the criminal code by sex workers, and of course the government response of Bill C-16, and yeah, I thought I'd give you a chance to go over this in as much clarity as I can provide, seeing as how you probably have questions about it from watching the video, and it's something that you need to know about. So again, most of you are familiar with the documentary, The New Era of Canadian... Okay, if we could start this again, that would be great. Actually, I'm just going to abandon it. This is the teaching lecture for Module 11, Prostitution in the Law. Starting now. Hello, human sexuality students. How are you doing today? I just wanted to take some time to go through the recent challenge by sex workers to the Canadian Criminal Code and the government's response to that in some detail, so you know what's going on. You will have become familiar with this when you watched the documentary, The New Era of Canadian Sex Work. For those of you that opted to skip that one, it might be worth just listening to, just to give you some context for this module. I looked at Bill C-36, which was recently passed in Canada, and it was the Canadian government's response to a challenge presented to the Canadian courts, where the sex workers brought a challenge saying that the laws around sex work that exist, as they exist now, are actually they actually violate sex workers' human rights. And smaller courts upheld this, and then the Supreme Court of Canada upheld this, and the government was given a year to respond to those challenges, and that's what this is all about in a nutshell. So let me just give you a step-by-step breakdown of the legal challenges that lead to Bill C-36. But before I do that, just a little introduction about the legal history of sex work in Canada. 1759 was the first recorded laws against sex trade work in Canada. In the second half of the 19th century, brothels outnumbered churches 6-1. At least in Victoria, BC. And in 1892, laws relating to brothels and street-based sex trade work became part of the criminal code. And it's these laws, actually, that are being heavily debated now across Canada. So a lot of the stuff that I'm going to tell you is based on an article about the challenges done by Shaver Lewis and Matissa Tyndale. If you wanted to look at that, or a presentation on that, you can try this link that I've given you here. So in 2007, this all began then, when sex workers bonded together to launch a legal challenge in the Superior Courts of Ontario and BC. And they said that sections of the Canadian Criminal Code violated their rights by increasing the risks that workers face on and off the job. So the risks associated with marginalization, stigma, negative attitudes. They said that the working conditions that they had to that they were forced to endure because of the Criminal Code of Canada made their lives unsafe. And there's a kind of assumption here that sex work is going to happen, whether you consider it illegal or legal, moral or immoral, and that as citizens of Canada, those who engage in sex work should be protected. So basically, they challenged 3 specific sections of the Canadian Criminal Code, and we'll talk about each of these. Section 210 prohibits the operation of common body houses, or the term that we would use is probably brothels. And the sex worker said this law prevents prostitutes from offering their services in safe indoor places, or even at other homes, or actual brothels. And the advantage for being able to to be able to perform sex trade work indoors as opposed to on the streets is that you can control the clients that come in. You have a lot more safety when you're controlling the place and time. And you can have networks in place that will protect you from just anybody pulling up in a car and grabbing you. Then they challenged the next section, which prohibits living on the avails of prostitution. Now, the intent, I think, of this law was that pimps who make their money off of prostituting young girls could be legally challenged with becoming rich off of the money that those girls make. And but the actual wording of the law means that anyone technically found to be living off the money that a prostitute earns or a sex worker earns could be charged with a criminal violation. And so that means that, for instance, if you're a sex worker, you can't hire an accountant because the accountant would then be breaking the law, and you can't hire a security guard, for instance, to look out for you because the security guard would be breaking the law. So they challenged that part of the law. And then finally, they prohibit communication for the purpose of prostitution in public. And this means that prostitutes kind of have to offer, especially street prostitutes, their wares on the darkest street corners where they can't be seen by police, which means that they're offering their services on the darkest street corners where they can't be seen or protected by police, if you get my drift. So here, this just breaks it down. Laws against keeping a common body house prevent sex workers from working indoors where it's safer. Laws against communication for the purposes of prostitution prevent them from taking time to talk to a potential client to assess any potential risk. And laws against living off the avails of prostitution prevent them from hiring bodyguards. So that's it in a nutshell. In September 2010, the 3 CC Canadian Criminal Code provisions related to the prostitution were ruled unconstitutional. That means that the provincial courts agreed that they increased the risk of harm to people working in the sex industry. So this might seem like a huge decision for sex trade workers. But what happened was the federal government of Canada decided to appeal this and say, well, you know, we don't think this is actually right, and we're going to launch a formal appeal. So in 2012, the Ontario Superior Court meets to decide the federal government or the Attorney General of Canada's appeal to the earlier decision. And we'll take each of, and it comes to conclusions. So we'll take the Superior Court's conclusions section by section by section. All right? So in terms of Section 210, the Superior Court said that we agree with the application judge, that's the provincial judge, that the prohibition on common body houses for the purpose of prostitution is unconstitutional and must be struck down. So that means they agree that prostitutes should be allowed to meet indoors or in organized brothels. This is the kicker, however. However, we suspend the declaration of invalidity for 12 months to give Parliament an opportunity to redraft a charter-compliant provision. So that is, they're giving the government a year to change the Criminal Code of Canada to make it consistent with this ruling. In terms of the appeal to Section 212, here's what they judged. They said, we also hold that the prostitution on living in the avails of prostitution infringes the Charter to the extent that it criminalizes non-exploitative commercial relationships between prostitutes and other people. But they kind of made a quid pro quo. They made a, I'm sorry to have thrown a raspberry at you. They made an exception. They said that, well, we don't strike down the prohibition because they still want to be able to arrest pimps and sex traffickers. But they do want to word that law so that people like accountants or bodyguards won't be charged with doing something illegal. And then finally, on the third section, the Superior Court responded with, "We do not agree with the application judge's conclusion that the ban on communicating in public for the purpose of prostitution is unconstitutional, and we will allow the appeal on that issue." So in sum, this is what happened. The Superior Court upheld kind of 1.5 of the provincial court's rulings and struck down the third one. So they said they agreed with the challenge to Section 210, that it prohibited the operation of body houses. They suggested rewording Section 212, which would still prohibit pimps and sex traffickers from profiting off of the funds earned by sex trade workers, but would allow for other people like accountants or child care workers or bodyguards to do that without breaking the law. And then they struck down the third law. So even having, even though the Superior Court didn't uphold all the provincial court rulings, this was still seen by the sex trade workers as a real step forward. Now, the key is they gave the federal government a year to comply with their ruling. So to adjust the sections of the criminal code to better reflect the rights of sex trade workers as citizens of Canada. These are ongoing concerns. Even when, if these laws were enacted, there'd still be exposure to danger and health risks. Sex trade workers would still experience discrimination and prejudice. And it would still be a problem, you know, knowing that sex trade workers, if they were attacked, could they go to the police? Can they declare income? Lots of other problems that weren't addressed in these laws, but some of the major ones were. So the government took a year, and the Conservative Government of Canada came back with Bill C-36. And again, I could have given you stuff, the actual bill. It's really hard to read, so I've set up a link here, or I've given you the tag for a link here that gives you a reporter's concise evaluation or summation of the bill, which I think you might find easier to read. So you can check that link out directly if you'd like. So what the Government of Canada proposed was a bill legalizing the sale of sex, but not its purchase. So instead of charging the sex worker for selling sex, you can charge the person who's buying it. So the question is, how does this address the sex workers' concerns and the rulings of the courts? Well, let's try and figure that out. So this is just a section from the article I was telling you about. Canadian Justice Minister Peter MacKay speaks during a news conference on Parliament Hill in Ottawa on June 4th, 2014. Prostitutes in Canada will generally be allowed to sell their services, but for the first time it will be a crime to buy sex from them. So this is the gist of the law, but we'll take it one step at a time here. If you'd like to read the legislative summary of the bill, I've given you this link, but I'm going to go through it here to try and make it accessible and understandable. So, Bill C-36 in a nutshell, while it's still legal to sell sex, isn't it funny that that's not been illegal? It's now illegal to purchase sexual services or communication in any place for that purpose. So it's illegal to communicate in a public place or in any place open to public view that is or is next to a school ground, playground, or daycare center. And the government says this is a great victory for sex workers because it targets the Johns as opposed to the victims of prostitution. But what are the implications of this bill for sex workers? And does it address the demands that they started with? Another thing that Bill C-36 does, it amends the criminal code to modernize the offense that prohibits the procurement of persons for the purpose of prostitution by making it illegal to buy it. Ensures consistency between prostitution offenses and the existing human trafficking offenses. So they're trying to make a direct, and certainly there are links between prostitution and human sex trafficking, because often people who are sold into human sex trafficking are sold into prostitution. However, to equate the two completely does not address any of the concerns brought forth by the sex trade workers. But let's take it one issue at a time. Does C-36 address the 2012 Supreme Court of Canada's earlier decisions? Let's take it one step at a time. Well, it doesn't address the prohibition against body houses. It hasn't changed the law on that at all. It hasn't changed the law making it illegal to live off the avails of prostitution, and well, it didn't have to do anything about this law, and it didn't do anything about that law. So what it has done is kind of make, well, and those of you who watch the documentary will have a better sense of this, but what it has done is make it harder for especially street workers to be safe selling their services, because if they're even next to a playground or in a school, in a neighborhood that a school might be, or if they're anywhere that's deemed public, they have to move from those places. Otherwise, the people that they sell to won't buy from them. And so instead of being able to negotiate before they get into a car, they have to move to the shadiest, darkest part of the street to get into the car without negotiation. And again, the documentary does a really excellent job of talking about how Bill C-36 does affect sex trade workers. So hopefully this gives you a better idea of what the challenges to the bill were and what the government's response. And I leave you to make your own conclusions. Bye now.